Yes, Mr. Parkinson.
Okay, my lord. If I can start by answering the question posed before lunch, which is a response to Ms. Streeton's suggestion that a judgment was exercised. Certainly in the officer's report under challenge, that the noise impacts associated with the pergola were acceptable under policy LP8. And the first point is that judgment, we say, can't be seen in the report. And were that judgment to have been exercised, one would expect to see it in the report and see and understand the reasons why that conclusion had been reached. What the report says, so this is in the supplementary bundle, tab 17, page 93. Is that the lawful use of there's a long-standing lawful use of the premises as a restaurant, so it's 4 paragraphs down. Consequently, issues associated with this use, such as noise or parking, are not in question. And our submission is that is the officer saying noise impacts from the pergola are not capable of being taken into account because the restaurant use is lawful. Because nobody had suggested that the existing use of the rear area for storage and other incidental functions, or from the interior of the restaurant, should have any bearing on the application. That must be a reference to noise issues arising from the pergola. Now it's true, and South Bucks is authority for this amongst others, that there's no obligation to deal with every single point in an officer's report. But it's worth going back to South Bucks to see what's said. So it's tab 7 in the authorities bundle. And the relevant part that you were taking to is on page 81.
So as I understand your submission, it's the opposite effect. It was dealt with, but it was dealt with by saying it's not a material issue.
Yeah. A judgment or a conclusion was reached that it was something that they couldn't reach a judgment on, which is why we don't see the judgment anywhere. And that's a legal question. Is this something that's capable of being material? Once that judgment, and that's a question for the court, if it is capable of being material, if the judgment is then exercised, then obviously that can only be challenged on Wednesbury grounds, but we don't get to that stage of exercising the judgment. And my evidence for that is twofold. Firstly, the fact that we don't see it in the report and we would expect to, which is the point I'm dealing with now. So paragraph 34 of South Bucks quotes from the Bolton case and the judgment there of Lord Lloyd. And what's said here is that 5 lines down, what the Secretary of State must do is state his reasons in sufficient detail to enable the reader to know what conclusions he's reached on the principal important controversial issues. To require him to refer to every material consideration, however insignificant, and to deal with every argument, however peripheral, would be to impose an unjustifiable burden. Since there's no obligation to refer to every material consideration, only the main issues in dispute, the scope for drawing any inference that the decision maker has not fully understood the materiality of the matter decision will necessarily be limited to the main issues. So the point that's been made, albeit in the context of reasons challenges, is there's no obligation to refer to every material consideration, just those in relation to the main issues in dispute. But of course, noise, and in particular, the extent to which the pergola would facilitate a different character of noise impacts, was a main issue in dispute. It was central to the respondent's objections to the local authority. This was not a peripheral, insignificant material consideration. It was central. And therefore, had the council exercised the judgment, one would expect to see it. The fact this is not there is indicative of the fact that they erroneously took the view that they could not take those impacts into account. So that's the first reason why we say that judgment was never in fact exercised. And that conclusion can be reached just looking at the officer's report under challenge in its own terms. But I do rely on the fact that that is entirely consistent with the approach that was taken in the first officer's report, which is even clearer.
Yeah, will you share some?
And I took you to that before lunch. I mean, that is clear, that it is saying that this is something that they cannot take into account. So it may well be the case that officers concluded that policy LPA was complied with in relation to noise, but that was on the erroneous basis that officers could not take into account the fact that the pergola facilitated a more intensive and therefore noisy use of the rear garden. So that is the second point raised in the respondent's notice. The third point raised in the respondent's notice is the consistency point. And we only get to this point in the analysis if it's concluded that officers did in fact exercise a judgment that the noise impacts were acceptable. So they haven't committed the legal error that's set out in the second respondent's notice point. And issue 3 in the respondent's notice is a pure reasons challenge. And it's this, that if regard was had to the potential impacts and a judgment was exercised that they were acceptable, there was a duty to give reasons to explain that judgment in the officer's report. And the source of that duty to give reasons comes from the consistency principle and the need to, where a decision maker reaches a decision that is inconsistent with a previous decision, both take that previous decision into account, but also give reasons for departing it from it, which is set out in the North Wiltshire case, which I'll come to in a second.
But what is the inconsistent decision that you rely on?
So
Certainly there is the officer's report leading to the refusal, which resulted in the unsuccessful appeal. The officer's report is not itself a decision, and the decision of the inspector is all about visual amenity and over-design and so forth. Although it is true that reading between the lines, one might think that she disagreed with what the officer had said about the impact of this structure, which I refuse, I'm afraid, to call a pergola.
Yeah. So it is if one just looked at the decision notices, so the decision notice refusing permission originally, the appeal decision, and then the decision notice here granting permission, on the face of the decisions, there is no inconsistency, I agree, because for the reasons my lord says, but the principle in North Wiltshire applies to the reasoning as well. And the reasons are inconsistent because the inspector at paragraph 9 says that the impact of the pergola is to facilitate a different character of use. If the council did exercise a judgment that we don't see, that actually it didn't, that is an inconsistency in the reasoning between the second officer's report and the inspector, which cried out for explanation. So that's the basis for the third point in the respondent's notice, which, as I say, we only get to if you're satisfied that that judgment was exercised. So if I can just take you to the inspector's decision, it's tab 13. Page 62, and it's paragraph 9. And we've seen this quote before. Now, the appellant states that the inspector here isn't dealing with noise impacts and is just concerned with the reason for refusal under appeal, which related to the visual impact of the gazebo or pergola. Now, of course, it is true that the reason for refusal only related to the visual impact of the pergola rather than noise considerations. However, my submission is what the inspector is saying here goes beyond that. She's saying that the pergola permits a year-round rather than an occasional use of the garden, and the comments here are focused on the use to which the garden can be put with and without the pergola, and we see that it's my view that the use of such a garden area for occasional outside seating would be a very different prospect to the creation of a permanent large enclosed structure to facilitate year-round usage by restaurant guests. Now that comment did go beyond the scope of the reasons for refusal, and it must have done because the reason for refusal on visual amenity doesn't relate to the frequency with which the garden was actually used, but rather the design of the pergola. And certainly in the first officer's report, officers didn't rely on the fact that the existing use was lawful as somehow mitigating or reducing the impact of the design of the pergola. But actually we say the fact that the inspector has nonetheless chosen to comment on this aspect of the officer's report actually elevates its importance. She's chosen to comment on it, notwithstanding the fact that, strictly speaking, it wasn't relevant to the reason for refusal before her, potentially with one eye to the fact that even if she refused permission, the council may have to reconsider whether to permit a revised application in the future, which is what has in fact happened. So the fact that it fell outside the scope of the reason for refusal doesn't mean that she wasn't here talking about the use of the garden. And secondly, it doesn't mean that, to use the language of Lord Justice Mann in North Wiltshire, this wasn't a critical or crucial part of the reasoning for her decision. This is a decision that is in total 12 paragraphs, and she's devoted a whole paragraph to this particular point, clearly on the basis that she considered that it was important reasoning and important for her to express her disagreement with what officers had said in the second report. And that did create a duty, if the council was going to subsequently disagree with what the inspector said at paragraph 9, to state its reasons why. And it is somewhat rare for an inspector to directly comment on a line of reasoning in an officer's report and say she disagrees with it, and then to get an officer's report that uses exactly the same language as that with which the inspector disagreed, but not to comment on the fact that in between an inspector has said, actually, I don't agree with what's been said there. And that, I would submit, is a paradigm example of where the principle in North Wiltshire applies. Obviously, the council didn't have to agree with what the inspector had said here, but if they were going to say, actually, we disagree, there was a duty to explain why. And again, this point isn't answered by pointing to the fact that the appeal decision was taken into account. It clearly was. And it was clearly taken into account in considering design, because the second officer's report carefully goes through the changes to the design of the pergola and how that addresses the inspector's concerns in relation to design. And I don't say otherwise. But paragraph 9, for the reasons I've said, goes beyond that and was of relevance to noise. And if the council were to disagree with it, they were under a duty to explain why. And if I can then, just on that, deal with the summary in Bates, which you were also taken to, which is at tab 20. And there's a summary at page 324 to 325. And obviously none of these propositions are in dispute. The key one really is, I would submit, point 8, where a planning decision maker differs from an earlier decision maker on a crucial planning issue. He is thus required to grasp the intellectual nettle of the disagreement and explain his reasons for disagreeing in terms of analysis. So the question is, in the second officer's report, was the officer differing from the inspector on a crucial planning issue? And my submission would be yes. Noise, for the reasons I've said, was a key issue in determining that application. The officer was disagreeing, if we get to this stage in the argument, was disagreeing with the inspector. and no reasons are given in the officer's report to explain why. And that's why we say that even if you find that a judgment was exercised, albeit not expressed in the report, the fact that it's not expressed in the report itself gives rise to a legal error under point 3 of the respondent's notice, because there was a duty to give reasons to explain why a different judgment was being reached. So that's point 3, my lords, on the respondent's notice. If I can then turn to the Senior Courts Act points, which is set out in my learned friends.
Sorry, just to,
Yeah.
before we go there,
Yeah.
does the absence of express disagreement with the inspector, is that a separate ground of challenge, or does it inform your submission that there wasn't a judgment, because if there had been, then this would have been done?
I think the answer is both. So we rely on the absence of any consideration to say that a judgment wasn't exercised. That's the second respondent's notice point. And you'll reach a judgment on whether that argument's correct or not. But if you find that a judgment was reached, that still leaves the third point. So it's both.
Right, so we're going to section 31.2a.
31.2a. So there are 3 respondents' notice points. The first one relates to whether the conditions attached to the 2005 permission extend to the garden, which ties into the questions I was discussing at the beginning about the lawfulness of the use of the garden. And on that point, the appellant relies on the premises licence. The points that I was discussing just before lunch and post-lunch is dealt with at paragraph 31b of Moylan skeleton argument. And as I understand it, reliance isn't placed there on the premises licence to say that even if the council had closed its mind...
Sorry, this is the supplemental.
Supplemental. So it's in the application bundle tab 2.
Yeah.
So as I understand it, it's not being said that if the council had closed its mind to the potential for increased noise impacts from the pergola, that the premises licence could be relied on to show that the outcome was highly likely to have been the same. I mean, I'll deal with it anyway. So I understand that that point is only being run in relation to issue 1 on the respondent's notice, which is different and relates to how the council considered the lawful use of the garden. But as I say, I'll deal with it in any event. The first point is that obviously there's no consideration of the premises licence in the officer's report. So this isn't a case of the kind that we often see where the defendant can point to a different part of the reasoning under challenge to say that the error in question wouldn't have made a difference. We're firmly engaged in a hypothetical exercise of what the officers would have said had they taken into account the premises licence, either at the time that the decision under challenge was made or should the decision be quashed on a redetermination. And the simple point is, we don't know. And it can't be assumed, based on the material before the court, that officers would have been satisfied, had they considered this, that the premises licence conditions provided sufficient protection against noise disturbance. And that's for a few reasons. The first is that the conditions in the premises licence don't match up to the planning conditions attached to the 2005 permission. For example, they permit the restaurant to be open to customers for an additional half hour for 6 days of the week. So if we go to the licence at tab 5 of this bundle, page 22,
Yeah.
you see the opening hours of the premises, 12 to 11:30, Monday to Saturday. And of course, condition 2 on the 2005 permission requires the restaurant to be closed to customers at 11 o'clock. So that's an additional half an hour, which is permitted under the premises licence. And from the point of view of the respondent, who has young children whose bedroom overlooks the garden, the difference between the use ceasing at 11 o'clock and ceasing at 11:30 6 days a week is material, or potentially material. Secondly, and perhaps more fundamentally, if we go to page 31 of the licence, there's Annex 4 plans. There's a plan on the left and a plan on the right. The plan on the right is edged in red. And the edging in red doesn't include the pergola, it includes the restaurant itself.
Right, mine doesn't have red lines on it, so I can't tell.
Okay. So does it include thicker lines or not?
I've got, well, it's just a black and white copy.
Okay.
Is there a gap in, is
the street at the top? Where's the street? Is that the top or the bottom?
So the street's at the top.
The street's at the top, and then there's a sort of gardenish area, which looks as though it's got some trees and planters in it. And then you
Sorry, my lord. So there's two plans at Annex 4. There's the plan on the left and the inset plan on the right. So looking at the plan on the left, the street's at the top.
Sorry, what I have got on my page 31 looks like an excerpt from the ordnance map, bottom right-hand part of the page.
Yeah.
And on the left is a diagrammatic representation of the ground floor.
Yeah.
And if the street is at the top of the plan,
yeah,
it looks as though I go through some sort of area with planters and or shrubs or something like that.
Yeah.
Go into the restaurant.
Yeah.
Where there seem to be 4 or 5 tables.
Yeah.
And then there's an area which may well be the kitchen.
Yeah.
And then there are 2 loos below that.
Yeah.
Then there seems to be a gap.
Yeah.
And then there is what I take to be the structure.
Yeah.
Yeah, right. And the
That's
red line goes around what?
So the red line is not on the plan on the left, if I can just show it. It's on the inset ordnance survey map.
Oh, I see. It's only on the ordnance map.
Yeah.
Right.
And the red line covers the restaurant, so the building, number 208.
Mm-hmm.
And it also includes the structure right at the end of the garden, which I understand is used for storage and other purposes like that. But it doesn't cover the bit in the middle, which is where the structure in question.
Oh, I see. I hadn't realised that.
Well, it seems to me that it covers the building at the back, which is the garage, but then it looks like it goes over onto the what I had previously thought was the parking area.
So
Is the restaurant isn't immediately adjacent to the track or road, whatever it is, that goes to the back, is it?
no. So on this plan, Hampton Road runs there across the top.
Yes.
There's a patio area which matches up here at the
Yes.
front of the restaurant.
Then there's the. But is it just the building at the back, or is it the building and the bit beyond the building?
So I think it's just the building at the back.
Okay.
It doesn't include the red line. Certainly doesn't include the rear parking area. But I suppose our point is, whilst the garage or the storage area, whatever the building at the end of the garden is being used for, is covered by a licence, and the ground floor of number 208 is covered by the licence, the red line doesn't extend around the pergola. Now, I'm not going to make any submissions on what that means, but there is at the very least a question mark as to whether the licence therefore in fact covers operations within the pergola. And that is a matter which certainly the respondent would want to address were the decision to be quashed and remitted. So that's the second point. And then the third point is a more general point that
Thank you. Oh, I've just been given what seems to be a coloured copy.
Oh, I'm very
Much
grateful.
better,
Thank you.
Thank you very much. Yes,
Hopefully that matches up with what I said and
Yes.
makes what I said clearer.
yes, it does.
So that's another point that officers would have to grapple with, and another reason why the court, I would respectfully say, cannot be satisfied. That it's highly likely that officers would look at the licence and say, well, noise impacts from the pergola are likely to have been found to be acceptable on the basis of the conditions of the licence. But more generally, officers would need to grapple with the differences between the licensing and the planning regimes. For example, on matters such as the procedure by which conditions can be reviewed and the considerations to be taken into account when determining the conditions attached to premises licence as opposed to planning conditions. Because of course, if the licensing regime offered equivalent or better protection to planning conditions, then in most cases there would be no need for planning conditions to be imposed on uses such as this. Now, I'm not saying that, I'm not giving the answer to any of those questions. I'm simply saying that there is a lot that the respondent would want to say. There is a lot that officers would need to take into account before they could say, well, it may well be the case that the pergola would intensify the use of the garden. It may well be the case that the character of the use would significantly change, but there's a premises licence and therefore we can reach the view that the impacts are acceptable. That's a world away from the reasoning that we have in the officer's report.
Yep.
It involves all sorts of different considerations. And whilst it's clear that the court should not shy away from Senior Courts Act type defences, I would submit that this is very firmly in the category of the court being asked to exercise its own planning judgment on whether this premises licence would make the noise impacts associated with the pergola acceptable or not. And that's the function ultimately for the council. So that's...
That's just a completely different question.
Yeah.
The layout of the restaurant has changed completely from what it was in 2005.
Yeah.
Is that prospective, or is that actually what was it part of the 22 application that it all changed as well?
No, so this is covered actually in the judge's judgment in parts. What happened was we had the 2005 permission, there was then a 2006 permission for extensions to the rear.
Right.
Okay,
don't worry.
But what actually appears to have happened on the ground isn't what was permitted in 2006. I think the simple answer to my lord's question is what we see here is what's on the ground.
Okay.
Whether or not that's permitted by the permissions that have been granted is a separate question.
Yeah.
So the simple point on the Senior Court Act is if you're with me on the respondent's notice points, ultimately the only way to know whether the premises licence gives rise to a different outcome or not is to send it back to the council to see.
Yeah.
So, well, unless I can help any further, those are my submissions.
Thank you very much, Mr. Bott. Yes, Mr. Streeton, do you wish to reply?
Yes, my lord, if I may, and I'll reply first on the construction of the 2005 permission. On that, my first point is that my learned friend focused very heavily on the description of development. But when you construe a permission, you do not just read the description of the development. You construe the permission as a whole, having regard to any other document incorporated into it, including the plans, in the same way that you would with any other public document or a contractual document. You don't just read one part of it. And indeed, we see that in the judgment of Lord Justice Keane in Barnet, at paragraphs 16 to 18. For my Lord's note, that's tab 12, page 157, where he specifically addresses the misapplication by the inspector of his previous decision in the Shepway case, where the inspector said, well, I'm not going to look at the application documents. And it was said by Lord Justice Keane, no, it includes the documents incorporated such as the plans. So to focus on that, I say, is wrong in principle. Secondly, my learned friend has swerved the effect of Regulation 3.1, which defines the area to which the permission applies, absent something clear setting it aside. I do say that the word used in the description of development is far from clear and capable of disapplying that. That's my first submission. My second submission is that when you construe the decision letter, you do it as a whole and in accordance with the ordinary approach to inspector's decision letter. So the permission granted is the entirety of the decision letter, and you read that document in accordance with the ordinary approach to decision letters, namely fairly and as a whole without undue legalism. And when you do that, firstly you see from paragraphs 4 to 6 the express reference to the existing use of the garden as part of the shop. Secondly, the reference to granting planning permission in accordance with the plans, that's paragraph 11 of the decision letter. And thirdly, the reference to the future use of the rear part of the site, namely the garage, at decision letter paragraph 9. And it is inconsistent, I say irreconcilable with that, to suggest that the use of the word ground floor limited the consent simply to the building. My next point, my lord, is that there is an issue of absurdity, especially when one considers the position of the fire escape, because it must be anticipated that the fire escape is anticipated to be used in case of emergency. And it cannot have been the inspector's intention that in order to comply with the requirement to have a fire escape, people would be required to breach planning control every time they went out through that escape. That just cannot have been what the inspector intended. She must have anticipated the outdoor area could be used at the very least in an emergency by people who exited, and that would be a classic ancillary use of the outside space. I do say there's no rational way to read it other than that. And so...
Why is that so? If the fire escape gave access onto the street, you wouldn't say that people on the street while there was a fire were using the street as a restaurant, would you?
No, but you wouldn't need planning permission to use the highway to congregate an emergency, whereas you would need permission to use the private land for a purpose ancillary to the use of the restaurant.
Okay.
I think there's a material difference between those two, because the highway can be used by members of the public to pass and repass, which I'm sure would include as a means of escape in circumstance of an emergency, whereas you don't have those implied rights over the private land. I mean, and I think if one said that it was possible to use any piece of land other than in a manner ancillary to its primary use as a fire escape, then that would probably cause land use planning issues quite quickly. So I think that is
I
my
wonder
submission.
about that. I mean, unless you've got a terrible fire safety record, couldn't you rely on the GDA to give you temporary permission to assemble for an hour or two?
Well, my lord,
'Cause you
I
can
wouldn't know
use-
which
you
class
you
of
can
Schedule
use, can't
2
you, up to 28 days under the GDA, can't you?
well, on agricultural land, but I don't think you can use any land for any purpose for up to 28 days. I mean, if it was a field, absolutely you could. But I can't think of a class immediately under Schedule 2 that would enable you to do that. And then my final point is that when you read the consent, you also read it with reference to Article 2.3 of the Use Classes Order and land being used in connection with that primary use. And I would direct my lords back to the paragraphs I identified earlier in Brooks and Burton in the authorities
Yes.
bundle.
You needn't show us those.
No, I won't. I just wanted to get the reference for myself. It's page 47 at C to D.
Yeah.
I turn then to deal with the respondent's notice points. And before I make my main points, I just wanted to deal with what was said with reference to supplemental bundle tab 16, page 87, which is the objection letter from the claimant's wife. So if we might just look at that.
Just give me the tab again.
It's tab 16 of the supplemental bundle, page 87. And you were referred to points 3, 4 and 5.
Yeah.
And essentially my submission is that those each make a separate point, that's why they're separately numbered. Point 3 makes a point about noise, I quite accept that, and that's summarised in the report. Point 4 simply points back to what the inspector said. It doesn't make a separate point about noise going beyond what the inspector said. And point 5 makes an entirely different point, namely converting what's said to be private outdoor space into a commercial use. So that is a point essentially we say about the construction of the 2005 permission. It's saying, well, this isn't lawfully a restaurant already. That's what we say the point in point 5 is about. It's not. about noise. That's the point made in point 3. Turning then to make my main reply points on the respondent's notice. In my submission, this essentially turns on the interpretation of the officer's report. There's a difference between my learned friend and I as to what the officer's report means. My submission is that it's a finding of acceptability. His submission is that it's a finding that it was irrelevant, incapable of being relevant in planning terms. I say that my construction of that document is correct for the following reasons. Firstly, you cannot read across from the previous officer's report. It's not incorporated by reference. And as my learned friend fairly accepted, the relevant paragraph of the officer's report to which the challenge relates goes beyond what was in that previous report. Specifically, it deals with the relevance of conditions. And that is a separate level of analysis not contained within the previous report. Secondly, I say that that second level of analysis is inconsistent with my learned friend's submission. You would not consider mitigation if the issue was incapable in principle of being relevant. Mitigation doesn't matter if the point is incapable of being relevant. It's only at issue where the matter is one on which you have to exercise your judgment. And so in doing what he does and referring to conditions, the officer is plainly forming a judgment. Thirdly, because the report expressly concludes compliance with LP8. And that is a conclusion which the officer would have been incapable of reaching had he felt there were unacceptable impacts on noise. If it was felt that there were unacceptable noise impacts, the fact that those were incapable of justifying a refusal, then what the officer would have done is to find a conflict with LP8, but find that that was outweighed by other material considerations, namely the existence of a consent. So that simply isn't the analytic structure of the report. The report concludes in clear terms, 1, that there is mitigation in place, and 2, overall, that there is accordance with LP8 and therefore the development is acceptable. And in my submission, the officer did not need to do more than that. To find to the contrary would entirely undermine all of the established authorities on officers' reports, Faber, Maxwell and Mansell. It would be just the sort of legalism that this court has so frequently cautioned litigants against. My last 2 points, my Lord, are on section 31, 2A. The first of those is that the test under section 31, 2A is whether there would have been a substantially different outcome, not an identical outcome. It's different from the simplex test. It's not would it have made any difference, it's would it have been a substantially different outcome.
Highly likely.
Highly likely that the outcome would not have been substantially different. And there's a case, Wet Finishing Works, a judgment of Mr. Justice Singh, as he then was, I'm sorry I don't have it in, where he says they're two different things. So you need a high probability and you need not substantially different, which is different from not identical. My second point, really just for clarification, relates to the point my learned friend took on the plan at page 31 of the supplemental bundle. And just to be clear, there are different regulations in relation to the plans that you have to submit with a licence. It's, for my Lord's benefit, Regulation 23 of the Licensing Act 2003, Premises Licences and Clubs Premises Certificates Regulations 2005, but they specify that you have to show 1, where buildings are, and 2, where fixed structures or objects are, and 3, for example, where steps are. And so these plans together meet those regulations. But for my learned friend to say, oh, well, the red line is only around the building, that's because there's a different regulatory scheme there and you have to show different things on your plans. So I say that that doesn't go anywhere. In my submission, what this court must do is what the court in Gathercole enjoined it to do, which is to apply its mind objectively to whether the errors alleged would have made a difference or were highly likely not to make a substantial difference. And in my submission, once you do that on the evidence, you reach the conclusion that if there was an error, it wasn't one that would have made, was highly likely to have made a substantial difference. unless I can be of further assistance.
Thank you very much, Mr. Street. Well, thank you both for your very economical arguments. We will reserve our judgments. You will get a draft in the usual way. It comes with an embargo, which means what it says, so it can only be used for the purpose of agreeing any necessary corrections to the grammar and or agreeing a draft order disposing of the appeal. If you can't agree a draft order, then please make short submissions in writing and we will make the form of order that you consider to be appropriate. The future hand down will be done remotely by release via email and to the National Archives, so there will be no need for any further attendance. Thank you both very much.
Court rise, if able.